Next case is People of the State of Michigan versus Virgil Smith. Mr. Williams, can you please wait momentarily? You look familiar, Mr. Williams. Have you been here before?
Yes, it's been a long day.
You got a few more bruises, though.
Okay, please proceed.
Good afternoon, Jason Williams, Assistant Prosecuting Attorney from Wayne County for the people of the state of Michigan. Timothy Boffman is also at counsel's table with me. I'll reserve 2 minutes for rebuttal. The court must intervene in this case to correct the errors of the trial court and the Court of Appeals. The provisions of a plea agreement under which Mr. Smith agreed to resign and not hold office during the term of probation do not violate the Constitution or public policy. The resignation provision, which Mr. Smith voluntarily agreed to, was not an expulsion from office, and therefore did not infringe on the legislature's constitutional power to expel a member. And resignation and barred office provisions do not violate public policy as they serve important interests of punishment and rehabilitation. Trial court here erred in striking those provisions, and the Court of Appeals erred in affirming that decision. Both courts also violated the separation of powers by binding the prosecutor to a different plea agreement than the one she had negotiated with Mr. Smith. When a trial court strikes provisions of a plea agreement, it must allow the prosecutor to withdraw the plea. To not do so infringes on the prosecutor's charging authority. To remedy these errors, we ask that the court either reinstate the provisions of the plea agreement or vacate the plea agreement and return this case to its pretrial posture. I waive the remainder of my pre-trial zone and would be happy
Counsel,
to answer any questions.
good afternoon. I want to just jump right into the separation of powers question here. And explain to me, like, how is this not a public right versus a private right? In dealing with such a constitutional question, isn't this really a public right and not necessarily a private right, one that he's able to waive?
No person can be compelled to serve as an elected official. You know, Michigan recognizes that elected officials can resign, just as justices of this court can resign.
So let me give you a hypothetical, though, and this is something I was, thinking about, and just kind of, if you just indulge me and allow me to kind of walk through this with you. Let's just take a hypothetical, and let's take a situation where you have an incredibly popular state senator, and this state senator decides that they want to run for prosecutor, and they are going to seek office, and they're going to run for prosecutor. They then get charged with a criminal offense. Under the kind of arguments that you're putting forth, could the prosecutor then say to this state senator who kind of says publicly, hey, I'm going to run for prosecutor, could they say as a term of your plea bargain, you cannot run for prosecutor?
They could propose as a term of your plea bargain that you agree not to run for prosecutor. It's your decision. The official in that circumstances could always decide to proceed to trial, as long as there's a choice.
That wouldn't be a misuse of office for the prosecutor to eliminate competition?
Number one, I don't think a prosecutor would do that, but
I would hope not.
and if a prosecutor did do that, of course, they would be answerable to the electorate.
There's a lot of law out there across the entire country that says that there is a long-standing public policy against agreements that either impair the integrity of elections or impinge on the choice of voters. And the gist of it seems to be that we don't want people to be able to traffic in or trade in or barter with their office. and use that as consideration. So in the contract setting, in the civil setting, those contracts, types of contracts, if you withdraw from office, if you resign, if you, after being nominated, step down so we can sort of manipulate and make sure someone else wins and the public doesn't really have a free choice, those types of agreements are not enforceable. Why is this a provision, at least the resignation provision, why is it not very much like those provisions, albeit in the criminal setting?
Because a party can, an elected official can simply resign for any reason.
Civil setting too, right? They could do the same thing. It's a free country.
It's a
The
free
question
country.
is, do we want people trafficking in their office in this way?
I don't believe that under the circumstances that a person is trafficking in their office. They're simply,
They're using it as consideration, private consideration, and getting a personal private benefit for the decision, right? It's not done for the public benefit.
well, I disagree with that. Certainly, I think the Attorney General has pointed out in their brief in support of our position here that an elected official who commits a violent crime, certainly as part of atonement or humbling for the electorate, could agree to give up their office. And I don't think that doing so in the circumstances of plea agreements somehow renders that improper.
Is the resignation part of this case moot?
I don't believe so, because number one, the resignation, the provision itself can be reinstated, so the court can grant us the remedy that.
Well, we could reinstate the provision, but we can't go back to a time before the defendant in this case resigned, can we? He's already resigned.
He has resigned. That's correct.
He can't resign again.
No, but he would simply be in compliance with the provision. But I think that also, you know, there is an exception to the mootness doctrine for jurisprudentially significance that are likely to recur but evade review. And I think at this point in the proceedings, where we now have a published Court of Appeals case that's binding, that if this court doesn't intervene at this point, this issue will never arise again.
Why not?
Because there's a published Court of Appeals case that now says that it's unconstitutional to have these provisions in a plea agreement. They simply won't be part of any plea agreement in the future.
Let me switch horses sort of midstream and look at the bar to office provision. I'm wondering whether that's a provision that is used often by your office. So let me just ask the first question. Has it ever been used before in a plea agreement to your knowledge?
Not to my knowledge, but I would add that the resignation provision
I'm just trying to
has been
focus
used
on,
once prior by our office.
trying to focus on bar to office provisions. Are there any pending cases where the prosecutor feels that he or she needs in their quiver as an arrow the ability to require a defendant to not run for future office? Are there pending cases where that's being discussed?
Not to my knowledge in Wayne County. I don't know to the extent that there are issues in other counties.
Are
as
you
well.
aware of whether this has become a problem across the state of Michigan in other prosecutors' office or with the Attorney General, that they're not able to use this provision and therefore not able to get justice done for the people of Michigan? In other words, I'm trying to figure out.
That
why
would
is
be a
this-
question that you would have to ask the elected prosecutors
let
of
me-
other jurisdictions.
So let me ask you, why is this issue, just the bar to office, why is it jurisprudentially significant?
It's a
You never
significant-
used it before that you know of? You're not
And
planning to
we,
use it
and
again?
we the prosecutor may well elect to use it again in the future. You're simply removing an option. There's no constitutional impediment.
But you would agree,
the
well,
provision.
that begs the question of the entire case, I suppose, whether there's a constitutional or public policy impediment to it. I'm just trying to figure out why we're spending so much time and effort talking about it if it's not something that is pressing. You would agree that there's no pressing need for this, other than this particular case.
There may be future cases. And
But
under
if
the
the
Court of
past is
Appeals
a-
decision,
But if the
that option
past is
has
a
been
prologue,
removed.
there will not be, or it's unlikely, right?
Pardon me?
If the past is a prediction of the future, it's unlikely, because it doesn't appear this has been a practice.
I wouldn't say I wouldn't say it's unlikely. These cases are unusual, but they may well be a case in the future in which.
I mean, there's very little law out there on bar to office, or resignation for that matter.
That is correct, but at least with regards to the resignation provisions, I think that they are not uncommon throughout the country.
There's a lot of things
and-
that aren't uncommon that may not be on firm legal ground. Is that a legal argument? They're not uncommon?
Simply because something is not uncommon does not mean that it's not,
A lot of knots in that sentence.
yeah.
No, I understand. I'm just trying to understand why the bar, seriously, why the bar to office is jurisprudentially significant. If the Court of Appeals opinion, that portion of it were to be left in place, is that a pressing jurisprudentially significant issue for us?
Our position that it is. It's a clear error. It does remove an option from the prosecutor in future cases that may be appropriate as deemed by the prosecutor. And the prosecutor should have, as you put it, whatever arrows in their quill are necessarily to serve the interests of
Some are
justice.
more widely accepted and have been legally tested more than the ones we're discussing today. I'm sure you would agree with that. Some of the arrows in the prosecutor's quiver.
That's very true.
Even on the resignation side, there's really no law that supports that, is there?
There are a few cases from outside this jurisdiction. There certainly are none
But they point
until this one in
They all
Michigan.
point the other way, don't they?
There are two cases. One of them from the early 1980s, a district court judge in New York tried to submit his finding only on that district court judge. Not even recognized as binding by the Department of Justice, who doesn't follow it.
I
And then the
understand.
state of Maryland.
These are not typically legally tested, these agreements, because of their voluntary nature, right?
That's true. Most often, the defendants comply with them, the courts approve them. There simply is no appeal, so you don't see appellate court decisions on the issue. This is the rare instance and the first instance that I know of where a trial court judge has stricken provisions of the plea agreement and then bound the prosecutor to the remainder of the agreement, which, of course, our contention, I think, is clearly a violation of separation of powers.
Well, it's only persuasive and not dispositive, but I would call to your attention that it continues to be an official policy of the Justice Department and the United States Attorney's Office there that these kinds of agreements are appropriate. In fact, the Criminal Resources Manual of the Executive Office of the United States Attorney says in United States versus Richmond, the court questioned the propriety of using the plea bargaining process to negotiate the resignation from office of a congressman. The Criminal Division believes that this decision is incorrect on the merits. United States attorney personnel are therefore encouraged to continue to consider voluntary offers of resignation from office as a desirable feature in plea agreements with elected and appointed public officials at all levels of government. And unless I'm wrong, I think this was a rather helpful provision in terms of a plea understanding reached between the Justice Department and a former Vice President of the United States at an earlier time.
That's correct, as I've discussed in my brief. Vice President Spiro Agnew resigned as part of a plea agreement, and I don't think there was any outcry at that point in the proceeding, and certainly I think the ensuing years have shown that this is not a circumstances where there's great danger of prosecutorial overreach.
Why is this not a question for the voters? The forbearance question. Why is this not a question for voters? Why is this a determination that gets to be made by the government? Voters are aware of a person's
a
past
question-
and their issues, so
It's
why?
a determination that's made by the defendant as to
Right.
whether they are fit to run for office or whether they need to simply, I think it's a determination on the part of Mr. Smith that would have been best for him to sit on the sidelines for a period of time.
But why is that the government's? I guess my question is, and this is really kind of what I'm trying to focus on here, is that Why is that a government decision? I mean, ultimately, we're talking not resignation, but forbearance. We're talking about someone who being barred from running for office. Why is that a determination that the government ultimately gets to make in putting forth a deal? I mean, ultimately, anyone who tends to be facing a number of years in prison and the government comes to them and says, look, we're going to prosecute you unless you agree that you are not going to run for a position again. Ultimately, I think in a lot of ways, you can say that that's a person's choice, but let's look at the reality of it. So if you could just help me to understand, and again, I'm just trying to understand both sides as best as possible. But from your perspective, why is that the government's ability to ultimately tell me, if I choose not to vote for someone because they've got a problematic past or, their integrity is in question, isn't that the determination of the voter? Why does it get to be the determination of your office to ultimately make that decision?
Well, voters get to choose among candidates who are voluntarily choosing to seek office. The prosecutor, in the performance of her duties, and then does have the authority to advance or to act in furtherance of what she believes is the interest of the public, and that is.
Are there any limitations? Like, would you concede? We're not talking as much about resignation. We're talking about not allowing for someone to run in the future. Would you concede that there's any limitations to that, or can the government basically decide what its limitations are?
The government can propose limitations, but of course it's always the defendant's choice whether he wants to accept them. Mr. Smith could have declined this offer, could have gone to trial. Maybe he gets acquitted, maybe he gets convicted.
But going to trial is a big thing. I mean, going to trial is not an easy circumstance. I mean, most people, in terms of the costs, and imagine for the time that you're going to trial, you're thinking about facing years in prison. I mean, it's not like it's that. In many situations, you're going to, for all practicality, you're going to tend to kind of go with the deal that's kind of put in front of you if it's a deal that's going to help to keep you out of prison. So the question is, again, I'm not focusing as much on this individual as much as I'm focusing on our separation of powers issue. And I take you back to the initial question, which is there any limitation as to what the government can put forth in a deal, put forth in a proffer?
In this context, I think it would be improper to put forth a provision that would bar the candidate from running in perpetuity because the court only has authority over the defendant during the term of probation.
But you determine what that would be. I mean, in the offer, you're going to say how long that, you're going to make a recommendation for how long that period would ultimately be, don't you?
Yes, in the performance of the prosecutor's duty. The prosecutor has the authority to do that.
So let me ask you, and I don't have many more questions. I just have just a few more questions for you. And I'm just trying to understand the position and try to understand kind of where we're at. Would you concede that let's take this out of the governmental context, and let's simply say that somebody is facing some significant charges. We're not talking about, charges that aren't directly related to the position that they hold. So let's just take an example of a surgeon. Outstanding surgeon, they have a problem with shoplifting, and you present them a deal and you say, now obviously they've got an issue with shoplifting and no one would condone that, but it doesn't necessarily go to, the crime doesn't necessarily go to their position as a surgeon. Would you have the right, under your argument, to be able to put forth a deal saying that you have to give up your surgical license and you can't perform as a physician?
The prosecutor has a right to propose that condition of the plea agreement. Again, a court, in the exercise of its discretion in sentencing, may choose not to accept that plea agreement.
I just want to understand your argument. So your argument is that there's really just no limitation. You could say to someone, ultimately, let's say you have a crime that doesn't have a nexus to that person's position. And it would be your position that you could basically say, let's just say, whatever the job is, you believe that you could put forth any offer, and you could simply say that, okay, you know what, you're looking at some significant, prison time here because whatever, you have an issue with shoplifting, and, I want to tell you, if you, the only way you're going to stay out of trial is you can no longer be a dentist, or you can no longer be a teacher, or you no longer can be a pilot. You would have the right to kind of put forth provisions of a deal that could bar somebody from their profession. And your answer back is that the only limitation on that would be is to whether the presiding judge would accept the deal.
No, certainly the prosecutor could not propose an unconstitutional provisions in a plea agreement. But short of a constitutional violation, that's within the authority of the prosecutor to propose, subject, of course, to the court's approval of the ultimate plea agreement and the defendant's choice to enter into it.
Thank you.
I mean, the premise of that question seems to be that there's no limitations upon the breadth of a plea agreement that the prosecutor might be interested in. But the prosecutor has an interest in actually achieving the plea too, and he's going to be checked by the fact that if he presents some wild and extreme conditions, that will not be acceptable to the party. The more conditions you have available to the prosecutor, in a sense, it seems to me is of greater value to the defendant than it is to the prosecutor. It's the defendant who faces maximum criminal exposure, and if a plea is insufficiently attractive to the prosecutor because it can't include, say, a resignation from public office, it's the defendant who suffers. And it's not his constituency who suffers, and it's not his next-door neighbor that suffers. If there is not a provision that would allow you to impose a resignation provision, and you believe that that's necessary to the plea, you won't enter into the plea, and Virgil Smith may face a prosecution and sanctions that are much greater than he wants to risk.
That's correct, Your Honor.
Thank you.
These provisions are in the interest of the defendant as well. Is there anything
Okay.
further?
Thank you very much, Mr. Williams.
Good afternoon, Your Honors. Catherine Marcus from the State Appellate Defender Office on behalf of Mr. Virgil Smith. My colleague Erin Van Kampen is at counsel table with me. There's no authority for the principle that only an actual exercise of the power of another branch of government can violate the separation of powers. Courts have outlined a number of ways that the separation of powers can be violated. The most relevant standard here is the one that the United States Supreme Court set out in Morrison v. Olson. And that's that the separation of powers is violated when one branch interferes with a particular power of another branch, or where there's encroachment by one branch on another branch that compromises the independence of that branch. And this court most recently applied the Morrison test in Lewis v. State. It's not cited in my brief, but you can find it at 464 Mich. 781. The prosecutor violated the separation of powers here when she used the threat of prosecution and imprisonment to secure Mr. Smith's resignation and the forbearance to hold elected or appointed office.
So if the public official was not, as it was in this case, a state senator, but it was instead, for example, the lieutenant governor of the state, that would not be a separation of powers issue, since we have both the prosecutor and the lieutenant governor being a member of the same branch. Is that correct?
Your Honor, here the Michigan Constitution expressly sets out to the legislature the power to be the sole judge of the qualifications of its members.
My question is, though, if instead of this being a state senator, and I understand there's different laws and different statutes, but you're arguing it's a constitutional problem as well,
Yes.
focusing on Article 3, Section 2, right?
Correct.
So I'm wondering if it is the lieutenant governor who stands in jeopardy here. Is that not a similar kind of problem because he and the prosecutor belong to the same branch?
There would not be the same separation of powers problem because it wouldn't be one branch interfering with a core function of another branch, and it wouldn't be one branch compromising the independence of another branch. There might be public policy considerations. But here, the separation of powers is violated because the executive branch interfered with the core function of the legislative branch, as set out in the Michigan Constitution, to be the sole judge of the qualifications of its members. And it also, in attempting to control who serves on the legislature, compromised the independence of the legislature. And as the trial court and the Court of Appeals noted, this practice carries the potential of real harm and abuse. It might not be front and center in this case, but the separation of powers is a structural safeguard, and courts have to police the boundaries irrespective of intent.
You know, if there wasn't a formal agreement and the prosecutor said to defense counsel, you know, if the senator decided to resign, I'd probably look at this case quite differently. And then the next day the senator resigns voluntarily. Does that do away with the problem?
I think that creates a different problem, Your Honor.
What would that be?
And that is that in order to be valid, the threats and promises that make up the plea have to be on the record. So if there is consideration that's happening that's not part of the agreement and that's relied on and it's not part of the record of the plea, then those threats and promises outside of the...
There is no plea agreement. The prosecutor just says if there was a resignation, I'd look at this case differently.
Mm-hmm.
Promising nothing other than to look at the case differently. That's nothing you can take to a court and enforce. Does the problem go away?
I think that's a very different situation. But if there was...
Does the constitutional problem go away?
Does the constitutional problem go away? There's still problems with I guess over the long run, compromising the independence of the legislature if this was a pattern of behavior. And I think there'd also be a problem if it was more of a promise and then the defendant pled and this promise wasn't anywhere in the plea agreement.
Okay, so let's take it down that road. The defendant pleads and the promise is in the plea agreement. Doesn't the defendant come to court and say, I resigned, I'm entitled to have a probationary sentence or something, less. I did what was asked of me. I voluntarily did what was asked of me. I want a reduced sentence.
The defendant would have a problem if that that agreement wasn't part of the record, saying I did what was asked of me. I guess that's what I'm trying to say.
The whole point is you're precluding the defendant from the opportunity to negotiate a resolution of criminal charges that is in his or her own best interest here. You're saying that the prosecutor can't take this into account, and I think that works to the detriment of the defendant.
I think that it could in certain cases. But where conditions violate public policy and violate the separation of powers, the institutional interest of the separation of powers, then an individual can't waive that away, even if it is for their own benefit.
So it violates public policy to say it's up to you. If you resign, you'll get leniency, and if you don't, we're going to pursue the charges with full force.
No, I don't think that violates public policy in the same way that the agreement does in this case, Your Honor. And I think that there's some potential problems with the scenario that you outlined, but it's not what we have before us here. What we have before us here is essentially resign and don't run for office or hold office for 5 years, or you're going to go to prison. And that violates public policy because the interest...
Is it or you'll go to prison, or we're going to pursue these charges to the full extent permissible? You get your right to a jury trial. You might be found innocent. You take your chance.
That's correct.
Right?
Right. The threat of prosecution and imprisonment, which in this case, it was there was a mandatory 2-year prison sentence for the felony firearm count.
Right.
And that is what Mr. Smith was trying to avoid.
Right. He took full advantage by voluntarily doing what was requested of him. But you would have us conclude that that's constitutionally barred.
Yes.
And in this case, you wouldn't want the prosecutor to have the opportunity to start from scratch. But in future cases, defendants facing similar situations would be denied the opportunity to negotiate a plea that's in their personal best interest.
It is constitutionally barred because we look at the actions of the branch when we're looking at a separation of powers violation, not the actions of Mr. Smith. We're looking at what the executive branch did, and did the executive branch encroach upon or compromise the independence, encroach upon this function or compromise the independence of the legislative branch. And Mr. Smith.
Is the answer to Justice Sarah's question informed by the cases I was discussing with opposing counsel earlier about the common law rule pretty much everywhere that an elected official or someone nominated for office can't barter with their office? In other words, those people too, it would be not in their interest, right? If they weren't able to derive some personal benefit by trading their office, by withdrawing from office or declining, or I guess it would be withdrawing. So the fact that it's not in their interest, or that it might be in this case beneficial to the defendant's not really the proper inquiry, is it?
That's correct, Your Honor.
So can I follow up on that? I thought that's why I thought in some ways your public policy argument, I'm not sure, I might have thought of your public policy argument differently than you do, so let me tell you how I was thinking about it, because I wasn't sure that it depended on your separation of powers argument. I thought your public policy argument was, your best public policy argument is based in the cases Justice Viviano was talking about, which is we don't let candidates, just for their own benefit, withdraw or take themselves out of an election because there's something bigger at stake. The policy is we don't want that kind of self-dealing with public offices because it affects the public. And so really, in a way, it's the benefit to Mr. Smith, not this branch of government, that we should be concerned about here. That someone in his position might want to bargain with their own public office to get a benefit just for themselves. And that we don't, as a matter of public policy, these cases tell us we don't like. And that is sort of like, there are other areas where we say, in the right to a public trial, there are a lot of times where a criminal defendant will say, yeah, you can close the courtroom. I'm happy to have the courtroom closed while, so-and-so testifies. And courts have said, no, too bad, it's not your right. It's the public's right to have an open courtroom. Sometimes there is this interest that the public has that conflicts with what the defendant wants to do. And so how does that affect this kind of agreement when it's not between two candidates, but it's between an elected official and a prosecutor?
Your Honor is correct. The public policy argument is separate from the separation of powers argument, and the public policy argument is based on the idea that the interest in the enforcement of this agreement is outweighed by the right of the people to elect the representatives of their choice. And the effect of the agreement is to reduce the scope of candidates, to remove an elected official that the people have chosen. And courts have recognized over and over again that the harm is not just to the candidate, but to the people that support that candidate. And the Davies court, which the Davies opinion that this court cited in its order, cites to a lot of voting rights cases that have that principle. Anderson v. Celebret, say others are Thornburg, California, Democratic Party v. Jones. They all have this principle that the people have the right to elect the representative of their choice.
Davies looks at whether the criminal conduct alleged has anything to do with the office, the public office involved as well. Here, there appears to be no nexus at all, correct?
That's correct, and that makes me think of something that I wanted to point out. Justice Markman, you asked about the United States Department of Justice manual, and I think what's being left out in the discussion of that is that the general rule says, they're saying these plea negotiations with resignation and forbearance remain appropriate and desirable objectives in plea negotiations with public officials who are charged with federal offenses that focus on abuse of the offices involved. So even in the DOJ's manual saying we're going to ignore the decision in Richmond, they're only endorsing this practice where there is where the offenses are connected to the office and deal with abuse of the office.
So the public policy argument fades away if it's public corruption, but anything short of some crime involving how the elected official represents the people, and then they cannot do it?
The public policy argument, if it's this balancing test, there's the rights of the voters on one end, and then on the other end, criminal justice interests. And in this case, there are minimal to no criminal justice interests, where I guess there might be more if the offense was connected to the official's office. Opposing counsel has suggested that these provisions were meant as rehabilitation, but that's nowhere in the trial court record. They were never presented as that way, and it's hard to see how they could be.
So by your analysis, a resignation provision would be okay with regard to an appointed official, but not an elected official, is that right?
As a matter of public policy, or in the separation
As
of
a matter of
powers?
constitution and public policy. I mean, there's no constituency in the same sense there that would be for an elected official. is
That's
that right?
correct. So it wouldn't have the same public policy concerns because it wouldn't engage the right of the electorate. And it wouldn't have the same separation of powers concerns because it wouldn't infringe upon the legislature's sole power to be the sole judge of the qualifications of its members. Beyond that,
I like to look at things holistically, and I guess my question to you, and if you can help me understand this, is did your client assume a certain risk by running for office? I mean, ultimately, if I'm not mistaken, and make sure I'm right on the facts here, but when the Court of Appeals came down with their determination focusing on mootness, didn't he file his papers like within that day?
I'm not sure how soon it was. I know that it was right around the same time.
So just to walk me through this here, just kind of looking at this from a pragmatic perspective, you had a case that was dismissed on mootness, and then a certain period of time afterwards, the determination or the decision was made to then run for office. Is there a certain level of risk that does kind of come with that we should be kind of cognizant of or weigh in our determination?
I suppose there's the risk of the prosecutor continuing to seek to appeal, but Mr. Smith has always complied with the terms of the agreement as the trial court imposed it.
No, I understand, but the issue with the running for office, I can totally appreciate that he served 10 months and that's an incredibly difficult thing. I mean, that's a very challenging thing. I totally recognize that. My question is that just looking at this from a certain kind of pragmatic principle, the court dismissed it, but it was dismissed on mootness. So the question is, if the case is dismissed on mootness and then you go and file, isn't that something that we should be kind of cognizant of in terms of the idea that is there a little bit of a risk that is taken when you decide to do that?
When the trial court struck those provisions from the plea and issued a judgment of sentence without those provisions, Mr. Smith was free to not resign or free to run for office
Right.
during the time of his probation. He resigned voluntarily.
Right.
There was nothing legally keeping him from doing that, and he is appellee in this case. So I think there's certainly the risk that this case continues to go on and on for him because that encouraged the prosecutor to then appeal to this court. But I'm not sure what you mean by risk beyond that.
I guess my question is that you're in a situation like this, you have a deal, you've made a deal, and then ultimately you then decide, you're in the middle of this. I understand the things that we've talked about before, but you ultimately voluntarily decide to run for office. And I guess my question is that something that we should take into account as the fact that there is a certain level of risk that you assume when you decide to do that?
No, Your Honor, I don't think so.
Okay, I appreciate it. Thank you very much, counsel.
Any
Thank you.
further questions? Thank you, counsel. Case will be submitted.